Finlayson.
Mr Chairman, I'll just make a couple of preliminary comments about Part 1. The part sets out, not surprisingly given its called preliminary provisions, certain preliminary provisions. These outline the purpose of the bill. There's the very important and carefully defined treaty clause, and it provides some definition of two terms, accommodated activity and deemed accommodated activity. These are activities which don't fall within the customary marine title permission rights. There are a number of amendments which are in the substantive SOP. Clauses 8 and 9 are going to be moved from Part 1, and it's proposed that they be located within Part 3 before the RMA and conservation permission rights to which they relate. And the terms accommodated activity and deemed accommodated activity have been very carefully refined to ensure they better reflect the policy intent and improve their workability. It's also proposed that the clauses which actually repeal the Foreshore and Seabed Act and restore customary interests be moved from clauses 14 and 15 to immediately after the purpose clause, and that is why to is proposed in the. There are a couple of other clauses I wouldn't mind just briefly referring to. Clause 6 is actually an important clause because in the course of a number of submissions that were made to the Select Committee, as I understand it, and also in the course of a number of written submissions, hell, fire and brimstone has been aired to the effect that if this legislation passes, New Zealand's sovereignty will somehow be diminished. Well, of course, that is to address the very point which the Court of Appeal said was mistaken, to conflate concepts of ownership and sovereignty. And so on 6 February 1840, when the Treaty of Waitangi was signed, the British Crown sovereignty of Aotearoa New Zealand. But at that time, Indigenous property rights continued to exist. In other words, the assumption of sovereignty did not undermine those ownership rights. And time again, speaking of the last period, particularly of weeks, we have got up and raised those matters with me, and I've had to say to them that ownership and sovereignty are two different concepts. So Clause 6 deals with that issue, and the SOP redrafts it, not to alter anything substantively, but to set it out more clearly. Clause 7 is the interpretation clause. There are a couple of points which are worth making here. The first deals with the definition of the common marine and coastal area, and subclause A refers to those parts which are held in fee simple. So specified freehold land located in the area will not be included in the common marine and coastal area. And I thought that the position was very well articulated in response to the Green Party member's speech by the Honourable David Parker, that nothing is to be gained by essentially indulging in a confiscation of land held in freehold title. And it's important for the member for the Green Party who says that she adopts such a beautiful, pure approach to these matters, that the effect of what she is seeking would be to remove and put into the customary marine title area general land owned by Pākehā, general land owned by Maori, and also customary land. So I don't think that that's particularly wise, and we're not going to go there. We're not going to confiscate from Maori customary land or general and land they may own. I just want to say something about subclause C, which deals with the bed of Tawhanga Lagoon in the Chatham Islands, because there's some interesting background to that. In its, Mr Chairman, in its 2001 report, the Tribunal dealt with the position of Ngāti Mutunga and Moriori claims in the Chatham Islands, and they found that the lagoon should be vested in a body which was representative both of Ngāti Mutunga and of Moriori. In fact, Ngāti Mutunga had lodged a case in 1993 contesting the Tribunal finding, as they viewed the lagoon as their Maori customary land. The Maori Land Court adjourned the case for the Tribunal hearing of the Ngāti Apa case. So what we've done is rather than put it into the common marine and coastal area, it's specifically excluded at this stage because if it's put into the common marine and coastal area, it can't be used in a treaty settlement, and it's my fervent hope that at a point in the not-too-distant future we will be able to enter into negotiations both with Ngāti Mutunga and with Moriori and achieve a settlement which will deal with this lagoon. It should never have been put into Crown ownership in 2004. It's important that it not be moved across to the common marine and coastal area now so that it can be used in the settlement. The other aspects or the other definitions are very technical and I don't think I need take the time of the committee to deal with those.
Materia too, right?